You need one or you?
Hi, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm presiding judge here in County Court at Law number 2. And you have been asked to come to court today for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your more serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, state jail felony. Now, state jail felonies, the range of punishment for a state jail felony is minimum 6 months in the state jail and a maximum of up to 2 years in the state jail, and a fine that does not exceed $10,000. The range of punishment for a third-degree felony, minimum 2 years in the state jail, up to 10 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum 99 years of life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is the capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that punishment because, as I mentioned to you earlier, you have a misdemeanor case. Misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanor range of punishment is by a fine only. You cannot be given jail time, and the fine cannot be above or cannot exceed $500. Now, your misdemeanor cases, your Class C misdemeanor cases, are cases that start in the city court or the JP court, and they come to this court when a person is found guilty in the JP court or the city court, and then they appeal their case. They get a whole new trial in this court. The range of punishment does not change. It stays the same, which is a maximum of $500. Okay? And you cannot get any jail time. However, if you fail to pay the fine, or if you the fine was converted to community service and you fail to perform community service, then the court can issue what is called a Capers Pro fine. I'll explain that to you. Capers Pro fine is just a warrant for your arrest to pay the fine or sit the fine out in jail. Now, if a person sits the fine out in jail, they'll be credited at $100 per day for every day that they spend in jail, and that $100 will go toward the payment of the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. For the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor, and with the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days which is a year in the county jail, or a fine that does not exceed $4,000. Or you could be given both such fine and confinement. Now, a person can be eligible for probation, whereby they don't go to jail, they serve their sentence in the public. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, we only refer to as deferred adjudicated probation, means that when you get on this type of probation, you don't have a conviction on your record. And if you successfully complete probation, you won't have a conviction on your record, and the case will be dismissed. And you can get, or you may qualify for what is called a non-disclosure. Non-disclosure means that your record will be sealed to the general public. Therefore, the public cannot have access to it. Now, and when I use the term general public, what I'm talking about is, places in the community like mobile oil, or just places that are non-governmental. And the reason why I say that is because governmental agencies that are listed in the Code of Criminal Procedure can have access, but most of the public is a general public, so they cannot have access to your record if you get a non-disclosure. Now, the other type of probation is called regular probation. It's just adjudicated probation. We call it regular probation. It means that you do have a conviction on your record when you get placed on the probation. However, there is something that is called judicial clemency. What that means is the judge can set your conviction aside, and you will not have a conviction on your record. And however, if you get a subsequent conviction, meaning that if you get a conviction later on, then the case can be brought back up and it could be used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, I mentioned to you that one of the things about arraignment is the court can tell you what your rights are. Now, some of the rights that we're going to go over in a few minutes is, for example, your right to have an attorney. Now, your right to have an attorney on that clipboard that you have, you should have a page that is titled Judge's Explanation of Rights to Defendants Without Attorney. Okay, I'm going to go over this page with you, and we need to continue to counsel. I'm going to keep on referring back to this page because before we leave today, everybody's going to have to sign their name and make a choice as to whether or not they want to hire their own attorney, they want to apply for a court-appointed attorney, they want to represent themselves, okay? So this document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. And the three options are listed here. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you if you cannot afford to hire an attorney. And number three, you may represent yourself. That is, you may waive or give a right to have an attorney represent yourself. Now, the first sentence under number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Reset means that you'll be given another court date from today to give you time to hire an attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request, or you can ask the court to appoint an attorney to represent you. But you must first fill out a financial questionnaire. The financial questionnaire is also on the clipboard. It is a 3-page document that is titled Jefferson County Affidavit of Indians, or maybe just titled Affidavit of Indians. Now, listen to this. You will only have to read and sign this document if you are requesting a court-appointed attorney. If you're not requesting a court-appointed attorney, you don't have to worry about this form, and you don't have to worry about anything that I say regarding this form, okay? This is only for people who will be requesting, asking for a court-appointed attorney, okay? Now, what you would have to do is fill out the first page, okay? And then on the second page, you would have to fill out the top portion that is titled Defendant's Oath. And then at the middle portion, you have to fill that portion out. That's titled Unsworn Declaration by Defendant. And then you'll stop. Again, this is only for people who will be applying for a court-appointed attorney. Now, let's refer back to the first form that I said we was going to counsel and refer back to. The next sentence, the third sentence below number 3 states that you may not talk to a prosecutor unless you first sign a waiver of counsel. Now, this is only for people who will be representing themselves. So if you're not representing yourself, you don't have to worry about what I'm getting ready to say. Only for people who will be waiving their right to an attorney and represent themselves. So if you're wanting to represent yourself, you will have an opportunity to talk to the prosecutor. Prosecutors are assistant criminal district attorneys that work for the Jefferson County District Attorney's Office. You can talk to them because you are representing yourself, just like your lawyer can talk to the prosecutors. You'll be able to talk to the prosecutors. Why? Because you will be your own lawyer. Okay? And so you'll be representing yourself. You'll have an opportunity. We have 2 prosecutors in court. You'll be able to talk to them to see if y'all can work out something on your case. All right. But before you do that, you have to fill out a waiver of counsel. There's another document, and this is only for people representing themselves. If you're not representing yourself, you don't have to worry about this. For those people who want to represent themselves, you have to fill out this waiver that says waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You'd have to fill out this document, read it, and sign it, and then you'll have an opportunity to talk to the prosecutor. Okay. Now going back to our first document, for those individuals who will be representing themselves, there's a paragraph here in block form. That paragraph states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time. For example, let's say you want to represent yourself. And then let's say you want to see if you can get unadjudicated probation or deferred probation, which means you won't have a conviction in the record. And so you talk to the prosecutor to see if y'all can work out a deal on it. And then the prosecutor say something like, no, I'm not going to agree to that. I'll give you jail. We're going to offer jail time or a fine or whatever. And you say, well, I don't want that. And you can say, well, Judge, I want to represent, I no longer want to represent myself. I want to see if I can get an attorney to represent. Okay? You can change your mind at any time. All right. Now, at the bottom of this document, in bold letters, it states defendant's choice, marking issues next to only one choice. Now, there are 5 lines to the side, to the left side at the bottom. You're going to make one choice. If you would like to hire your own attorney, you'll place your initials on the first line to the left, sign and date the bottom of this document, then just stop, and this is the only form that you would have to sign. Okay? If you have already hired an attorney, then you'll place your initials on the second line at the bottom to the left, and the name of the attorney on the line to the right. And then you'll sign the bottom of this document, date it, and then you'll stop. And this is the only form that you would have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. sign and date this form, and then you'll fill out this document that is titled Affidavit of Indians or Jefferson County Affidavit of Indians. And as I mentioned to you earlier, you'll fill out the first page of this document. And then you'll go to the second page and you'll fill out the top portion that's titled Defendant's Oath. And then the middle portion that is titled Unsworn Declaration by a Defendant, and then you'll stop. Now, if you've already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. You're gonna sign and date it at the bottom, and this is the only form that you would have to sign, and then you'll stop. Now, if you would like to just represent yourself, you don't want to have an attorney, you want to represent yourself, you'll place your initials on the fifth line at the bottom, sign this form, date it, and then you'll sign the waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You'll sign and date this form, and then you'll stop. All right. And just as a brief recap, if you want to represent yourself, if you want to hire an attorney, you'll sign this form. This is the only form you have to fill out. And if you have already hired an attorney, this is the only form that you have to fill out. If you would like to apply for a court-appointed attorney, you would place your name on the third line here on this document, sign and date it, and then fill out the affidavit of indigenous, first page, second page, and then you'll sign, and then you'll stop. If you would like to, if you've already been appointed a court-appointed attorney, then you'll place your initials on the fourth line, name of the attorney to the right, sign and date this form and stop. If you would like to represent yourself, then you'll place your initials the fifth line to the left, sign and date this form, and then you will read and sign and date the form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Okay, do we have any questions before I move on? Okay. Now, the next thing I need to tell you is that you have a right, if you enter a plea, if you enter a plea of guilty, not guilty, you have a right to have a trial. Now, you can have what we call the jury trial. This young man is sitting, Mr. Stewart, then 6 jurors will be selected to serve as jurors in your case. In essence, they'll listen to all the evidence that's presented by the state and the defense. They will listen to all of the arguments of the state and the defense, and then they will go back into the jury room to deliberate to decide whether to find you not guilty or guilty. You can waive, which means you can give up your right to have a jury trial. Now, if you waive or give up your right to have a jury trial, you will not be having a jury trial. You can have what is called a bench trial. A bench trial is a trial by judge only. The judge will be the judge and the jury in the case. The reason why they call it a bench trial is because the place that the judge sits in is called the bench. And so you have a right to have a bench trial, and the judge will listen to the arguments, listen to the evidence which is being presented by the state and the defense, listen to the arguments of the state and the defense, and then the judge will apply the facts to the law and decide whether to find you not guilty or guilty. Now, if you enter a plea of guilty or no contest, now, entering a plea of guilty, you're telling the court that you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you would not be fighting or you would not be contesting the charge. If you enter a plea of guilty and no contest, then you have the option to work out a plea bargain agreement with the state. A plea bargain agreement means that you want to see if y'all can settle the case. You just call it a plea bargain. It's a settlement on the case. And if you come to an agreement, to settle your case, we call that an agreed plea bargain. It's agreed. It comes before the judge. The judge can do one of two things. The judge can accept or reject the plea bargain agreement. Now, if the judge rejects your agreement, for example, let's say you're in the state talk, you want deferred probation, they offer you deferred probation, it goes before the judge said, well, I'm not gonna follow it, I'm not gonna accept it. Then if the judge does not accept the agreement, you have a right to take your plea back. You can say, well, judge, since you're not following the plea bargain agreement, I'm not entering a plea guilty and I'm not entering a plea no contest. I take my plea back. You have a right to do that. We call that you have a right to withdraw your plea. All right, now, if the judge does follow the plea bargain agreement, the judge says, okay, y'all come to the agreement, I accept that, I follow that agreement. Then if you decide within 30 days that you would like to appeal your case because you think that, well, you've been wrongfully convicted or the court committed an error by convicting you, then you have to get permission to appeal your case from the judge. Now, if the judge gives you permission to appeal your case will leave this court and it'll go right upstairs to the Ninth Court of Appeal. There are 4 judges up there. They review the case. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Or they can send the case back down to this case, or to this court to give you a whole new trial. If they deny your appeal, guess what? You can appeal it to another court. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. They are located in Austin, Texas. Now, you have to file what is called a pro se petition for discretionary review. I'll explain it to you. Pro se means self. You by yourself, you're not represented by an attorney. Petition for review, you're petitioning or asking the court to review your case. To see why are you asking to review your case? Because you want to see if your appeal should have been granted, or whether or not this court committed an error by convicting you, or whether or not to see whether or not you were wrongfully convicted. They can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty. Or they can send the case back up to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your petition at that point, then your conviction will stand. Now, you also have a right, you have a right to have witnesses to come to court. Witnesses can testify for you or against you. They sit in that chair where the microphone is. We call that the witness stand. They can testify for or against you. If you represent yourself, you can ask some questions. If you're a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses, meaning that you don't want to call a witness. Now, if you waive or give up your right to call witnesses, that does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have what is called a Fifth Amendment right against self-incrimination. I'll explain it too. The Fifth Amendment of the United States Constitution gives you a right to remain silent. Give us the right to remain silent. So the state, the government, the DA's office cannot force you to testify against yourself. Okay? If you think about it, it makes sense. Why? Because the state of Texas has the burden of proof, meaning that they have to prove that you're guilty of the offense that they charge you with, right? You don't have to prove yourself guilty. Okay? You don't have to say anything. It's their job. You don't have to do their job for you. All right. Now, the next thing that you have is the right I'm going to talk about is the right to have discovery. Discovery means you have a right to see the evidence, all the evidence that the state has and will be used against you. Okay? You have a right to see your statements, witness statements, police reports, lab reports, photos, video recordings. You have a right to listen to audio recordings, look at documents, have access to any instruments, whatever you have as evidence against you. You have a right to have access to that. That's called discovery. Now, you can waive or give up your right to discovery, but with your rights, you can waive any of these rights that I just mentioned, if you desire to do it. Now, everyone here, for a case, charges have been filed against you, you've been arrested, placed in Jefferson County Jail, you're bonded out, you're either out of a cash bond, which means that you pay the full amount of the bond to get out of jail, you're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a personal recognizance bond or a PR bond, which means that you did not have to pay any money to get out of jail. You were just released under your own personal recognizance with a promise to appear here today. I say that to say this. Every day that you spent in jail can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail. And let's say you talk to the prosecutor, he's offering you 5 days in jail. What that means is you won't have to do no more time in jail because you already did 5 days in jail. So you get what we call credit for time served. Now, if you did 5 days in jail and they offer 7, that means you don't have to do 2 because we'll subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail can also be used as fine and court costs. Credit towards your fine and court costs. You're credited for every 1 day that you spend in jail, you're credited up to $100 per day. So if you spend 5 days in jail, that's $500 that can be used to pay your fine and court costs. So if the state is offering you fine and court costs of $500, you spend 5 days in jail, you don't have to pay anything. Why? Because the time that you spent in jail has already paid it off, so it'll be taxed and retired. Now, if the state is offering fine and court costs of $700, that means you don't have to pay $200 because you already have $500 that's subtracted from the $700, that leaves $200. Now, you'll be required to pay that money on the day that you take care of the case. If you can't pay it, no problem, because we can put you on what is called a payment plan, which means you can pay it off in small monthly installments. Now, if we put you on a payment plan and you cannot pay a payment plan, no problem, because we can convert the fine and court costs to community service. And so every 1 hour of community service that you perform at a nonprofit organization in our community, $12.50 will go toward the payment of your fine and court costs. So just by some mathematics, if you do community service 8 hours 1 day, that's $100 that go towards your fine and court costs. So in our scenario, if you work 2 8-hour days, you work 2 days, 8 hours. That's $200 and it'll take care of the balance. All right. Now, Jefferson County has a program for first-time offenders. If you've never been in trouble before, the DA's office has a program that is called pretrial diversion, where they will dismiss your case. And then they'll wipe it off your record. You can get it wiped off your record. We call it an expunction. In order to qualify, 3 things has to happen. It has to be your first time getting into trouble with cases. And you have to have an attorney to assist you with the application process. You don't have to hire the attorney, can be appointed. So if you get a court-appointed attorney, they can do the same thing. And the third thing, it cannot be an offense for unlawful carrying a weapon or resisting arrest. All right? And so if you're interested in that program, just let us know. And if you have a lawyer, let your lawyer know. And then they can talk to the prosecutor to see if you can get into the program again where your case will be dismissed. And then you can get it erased or wiped off your record like it never happened. All right. Now, the next thing is if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. So veterans office, you just have to do that. And what they would do, you get into the program, they dismiss the case, and you can get a non-disclosure, which means that your record is sealed to the general public. This court, County Court Number 2, Jefferson County, Texas, has a program that go out there and to start within the first 100 days of taking office in March of 2017. That program is called the Community Safety Initiative, or the CSI program. And with that program, we have partnerships with various agencies in our Jefferson County area. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is a local mental health center in the Southeast Texas region. And they have the expertise to address any mental health needs that you have. Now, we have some folks from Spindletop. They're going to be coming out in a few minutes. They're going to just talk to you a little bit more about the program. But basically, what Spindletop will do, Spindletop will do a private interview. It could be in our jury room, it could be at their facilities, it could be by telephone, whichever is convenient for you. They also can do an assessment. An assessment meaning they can determine what your mental health problem may be. Now, and they can do develop a treatment plan for either outpatient or inpatient treatment. Now, in order to participate in the program, you do not have to be incompetent or insane. You could just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address those. Now, if you're having issues with drugs or alcohol, Spindletop has a drug and alcohol recovery program that is called ATAR. ATAR is an acronym that stands for Addiction Treatment and Recovery. We also have a partnership with the Golden Triangle, with our local drug and alcohol council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach Screening Assessment Referrals. Both of those programs are drug and alcohol recovery programs. And what they will do, they can do a private screening. They can do an assessment to determine what your issues may be, and they can develop a treatment plan for either outpatient or inpatient treatment. Now, if you're unemployed, you might be looking for a better job. We have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the chemical industry, and the shipping industry. And what they will do, once you get trained in one of the areas that you select, they will help you to get a job in the area that you trained in. Now, if you have not graduated from high school, you do not have a GED, they also have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And like I say in this court, we don't just give time. We take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crime. Why? Because they have too much to lose. And therefore, I like to say, when you come to county court at law number 2 of Jefferson County, Texas, we don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned, just let us know, and we can direct you to the persons or to the people that you need to talk to so that you can get on the road to living your best life. So at this time, we have, Caitlin and Mr. DeVille, who is with Spindletop. They're going to come to you and tell you a little bit more about the program that Spindletop has to offer.
Thank you. Good morning. I'm Josh Young with the Sheriff's Office. I'm with the Mental Health Division. I'm attached to Spindletop, and this is my partner, Kate. She's a qualified mental health professional. And the pamphlets we pass out to y'all, she can explain it to you a little bit in further detail.
So at the front of your clipboard, there should have been like a little half paper. It's like the smallest paper on the clipboard. That paper is optional. You do not have to fill it out. And if you already filled it out, that's fine. We'll just throw it away. But basically what that paper is to get you into Spindletop services or to help you find resources for the things that we offer. We offer help with mental health, which could be depression, anxiety, PTSD, or anything mental health related. We have a substance use program, and that can be any type of drugs, alcohol. For mental health, we have doctors who get you medication, we have therapists, counselors, we have support groups. For substance use, we have support groups for that, we have rehab, and then we have, classes or anything that you might be interested in. And if we don't offer something that you've heard about, then we can help you find that resource somewhere in the area or even. Again, our form is optional. You do not have to fill it out. You can leave it blank if you want to, because we can always reuse the paper. And if you want to talk to me about services or about getting into services, you can write on your paper, please talk to me today, and then I'll come and pull you out from here while the judge goes through. Anybody have any questions?
Okay, thank you, Caitlin, and
Thank you.
Deputy. At this time, we'll have, Mr. Johnny Stewart. He's with, Family Services. He's gonna tell you about the BIP program, data, intervention, prevention, program that the, county has in place for individuals who have cases involving family violence, where your case can get dismissed and it can get expunged from you.
Thank you, Judge, appreciate it. Good morning, everyone. I'm Johnny Stewart, I'm with the Family Services of Southeast Texas. And I am the BIP Director, Batterers Intervention and Prevention Program. It used to be called the Domestic Violence Program. But this program is one of the pretrial diversion programs. If this is your first time for committing some type of family violence offense. It's an 18-week program, 2 hours per session. We also have Zoom available for those who are working, so, and then we also have in-person classes. So this is to help you if you don't have a job, what have you. This program is to help you change behavior, not only help yourself, but also to help your family, Basically, we've been doing this program for many, many years. I've been doing it for 25 years. But take advantage of this program. It's been very successful. And also, once you finish the program, we'll provide you a certificate and also a certificate to the courts, and you have this removed from your record. So I would encourage you to, if you have an opportunity, to take advantage. So, and I appreciate your attention. Thank you.
Okay, thank you, Mr. Stewart.
Judge.
You're welcome. Okay, now, ladies and gentlemen, the paperwork that you have in your hands, we're gonna give you on the clipboards, we're gonna give you an opportunity to finish filling the paperwork out. If you need assistance with filling the paperwork out, we have our court personnel, including myself, who will be happy to help you to fill out the paperwork. Now, this is gonna take a few minutes. Once you fill out the paperwork, we're gonna call you up before the bench. One at a time, we're gonna put you into one of three categories. One, you wanna hire your own attorney. And if you're in that category, your case will be reset today and you'll be given a court date and you'll leave. Now, the second category is if you want to apply for a court-appointed attorney, then if you qualify, your attorney will be appointed today before you leave here. And the third category is if you would like to represent yourself. You have an opportunity to talk to the prosecutor, see if y'all can work out something. If you're able to work out a plea bargain, your case will be taken care of today. Now, as I mentioned to you earlier, this is gonna take a little time for you to finish filling out the paperwork and for us to pick it up. If you need to use the restroom, there are 2 restrooms right outside in the hall. There, we have a main restroom in front of County Court Law and the Free, which is right next door. To my right, your left. And the women's restroom is on the opposite side of the hall from the men's restroom in front of the 172nd District Court. Now, you'll be allowed to go out into the hall, use the restroom. Please do not leave the courthouse. If you leave the courthouse before your case is called, then a warrant, your bond can be forfeited and a warrant will be issued for your arrest. You'll be arrested, placed in jail, and guess what? We have to go through this all over again. And so we want to see if we can get everything done as soon as possible. And we can see if we can get you in and out as soon as possible. So if you have any questions, anybody have any questions before we go forward?
Is it possible if I'm not sure if I'm gonna represent myself or if I haven't had a chance to speak to an attorney?
Okay, well, I mean,
Well,
just because you haven't had a chance to speak to an attorney, I mean, like I said, you can make a choice to hire an attorney. If you make that, the case is gonna be reset, and then when you come back, if you haven't hired an attorney, you can tell us what you wanna do. Okay, if you need more time to hire an attorney, then we may have to give you more time. Okay,
alright.
okay, anybody else?
What's
Okay.
bail? Oh, your attorney already. She was in here earlier.
Bill,
Are you last name Bill?
just,
I'll talk to you in a little bit. Sorry, Judge, go ahead.
Oh, okay. Okay, we're gonna, be in recess. Make sure that you continue to conduct yourself accordingly. You're still in court. And so we're gonna try to get you in and out as soon as possible. Again, if you need help filling the paperwork, just let us know by raising your hand, and we'll come out. Our court person will come out and see if we can help, or I may call you up and we'll roll the paper, okay? So at this time, the court will be in recess. Thank you.
I'm not sure if he told you, but on the top of that, the page where it says, later check this verse.
State of Texas versus blank, yeah,
Yeah.
write your name on there.
Their printer name, so we can know, who it is.
Court is back in session. This Rama docket. First case is cause number 23-CCCR 1326. Case is styled. Oh, let me do this. This is gonna be sick. You still working? Okay. First case is, oh, I have two cases. Cause number 25-CCCR 2538 and cause number 25-CCCR 2539. Both cases are styled as state of Texas versus Elvin Bryant. We're not ready on your paperwork. Mr. Bryant, get him out of here. Mr. Bryant, your full name is Elvin Bryant Jr.?
Yes, sir.
Mr. Bryant, would you please raise your right hand? Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
No.
Mr. Bryant, you may put your hand down. How are you doing, Mr. Bryant?
Pretty good, Jeff.
That's good. Mr. Bryant, I have before me document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
Is this? Are these your initials on the line stating that you hired Bruce Smith?
Yes, sir.
And is this your signature?
Yes, sir.
Now, before you signed and initialed this document, did you read the document?
Yes, I did.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, Mr. Bryant, your cases will be reset to give Mr. Smith an opportunity to file his letter of representation. Our court coordinator is going to reset your cases. Once you reset your cases, you're free to go on your best day. Please have a seat in that first chair on the wall. You have that up on?
Yeah, I said it to you.
Yeah, first chair right there. This is Elijah Mahoney. Mr. Mahoney, your full name is Elijah Mahoney. Mr. Mahoney, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Mahoney, you may put your hand down. How are you doing, Mr. Mahoney? That's good. Now, Mr. Mahoney, I have two documents on paper before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state
Yes, sir.
you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Mahoney, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
That is correct, sir.
Now, Mr. Mahoney, before we go any further, I failed to mention to you that you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, sir.
Now, Mr. Mahoney, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Elijah Mahoney, on or about January 16th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense, failure to identify fugitive with intent to give false information. Mr. Mahoney, do you understand what you've been charged with?
Yes, sir.
To this charge, Mr. Mahoney, how do you plead? Guilty, not guilty, or no contest?
Plead guilty, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
I'm guilty.
Mr. Mahoney, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are 2 sets of initials. First set of initials on a line next to a box that is checked guilty. Did you place your initials on this document?
Yes, sir.
Second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discover in this case and choose to enter or plead guilty in no contest. Do you place your initials in this document?
Yes, sir. That is correct.
On page 3 of the same document, there is a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next page, that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes,
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement? The second box that's checked states that you're waiving your right to an appeal. You understand that statement?
Yes, sir.
Now, Mr. Mahoney, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Mahoney, are you a citizen of the United States?
Yes, sir.
State, you like to offer State's Exhibit number 1?
So offered, Your Honor.
Okay, now, Mr. Mahoney, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is this first document that I showed you. This is the same document that have your initials on page 3, and it has your signature on, with your signature on page 3, your initials on page 2. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objections. State's Exhibit number 1 is admitted. Mr. Mahoney, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Mr. Mahoney, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
180 days, jail time, judge, time served, time actually served, and all court costs should be taxed and retired. Is that correct, Mr. Mahoney? Is that correct?
Oh, yeah, yes, sir. Yes, sir. Yes, sir.
Okay, now, Mr. Mahoney, the state is offering that you serve 180 days in the Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already spent 180 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. It simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Mahoney, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Mahoney, I'll follow the plea bargain agreement that you have entered into with the state. You have respect for it.
Yes.
Mr. Mahoney, you're gonna stand at the end of that table.
If
Follow the
I
direction.
just may, Judge, I had the opportunity to speak with Mr. Mahoney, and these are one of like the cases to where an individual totally takes responsibility and how he's totally to totally like change things around and on such a positive path. I just thought I'd have to share that with the court judge for everything that, Elijah, I'm sorry, Mr. Mahoney's doing now, Judge.
Okay. Now, Mr. Mahoney, how old are you?
31.
31?
Yes, sir.
Well, you must be doing something good because you look pretty young to be 31. Whatever it is, you need to keep it up. You know what? I used to be 31 for 365 days. I was 31. You know, that was many moons ago. Now, Mr. Mahoney, you know, a lot of times, you know, people your age, young people these days say they have a BFF, best friend for life. That's the persons that they expect to be there through thick and thin. Sometimes y'all call them your ride or die. Okay. In my day, we used to call them our ace boon coon. Okay. Now, on days like today, I didn't see you here with anybody. You know, that person that you call your ride or die, your BFF, is not here. And the reason why they're not here is because, you know, they found that they had something better to do in life than to be down here with you. But, you know, I tell young people this all the time. Everybody is not your friend, and everybody's not your partner. But when God said he got you, he got you. Okay? And so, Mr. Mahoney, I know you might be thinking, well, you know, I'm here in court. This is probably the worst day of my life. You know, I'm an embarrassment to my folks. But you might think that you're in a storm. But just remember this: when you're walking through a storm, hold your head high and don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a law. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. You know, there's one thing about hope. Hope floats. And so when you're drowning in a sea of confusion, just hold on to that hope, and you'll keep your head above water. Okay? Now, Mr. Mahoney, some people might look at this as a stumbling block, but guess what? You can flip that and look at it as a stepping stone. And people use stepping stones to step to things to reach higher heights in life. So one only thing I'm trying to tell you, Mr. Mahoney, is that what happened here today is not going to stop you from accomplishing whatever you want to accomplish in your life. The prosecutor spoke highly of you. He said that you made some changes to your life. And I might tell you this, I forgot to tell you, you look pretty sharp today.
Thank you.
Okay. So just keep on doing what you're doing. Keep on keeping on, okay?
Sir.
And you'll be all right. All right. And just so as I mentioned to you earlier, you're going to stand at the end of that table, follow the directions of the bailiff. Once you finish following the direction of the bailiff, you'll be free to go. And I think he's working already.
Yes.
Okay, keep up the good work.
Sir.
All right, you have a blessed day.
You should come eat there sometime.
Huh.
Long.
Okay. Okay. I've been over there before.
Uh-huh.
Yeah. Yeah.
She's coming right.
Yeah.
Get
Yeah.
first.
Just have a seat in that chair and wait for her to come. Okay. Let's see. Darren Watson.
Oh,
Huh?
Mr. Lawrence can help you in this spot, Alvin Wayne.
Okay, well, let me get, okay. Watson, won't you come on up? Mr. Watson, your full name. Now, first of all, Mr. Watson, you had gum in your mouth? You get rid of that gum. All right, thanks. Now, Mr. Watson, your full name is Darren J. Watson. That's correct. How you doing, Mr. Watson? I'm doing fine, thanks, Sax. Now, Mr. Watson, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, Mr. Watson, you may put your hand down. Now, Mr. Watson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to hire your own attorney? Before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Watson, I read your answers. Your case is going to be reset to give you an opportunity to hire your own attorney. Our court coordinator is gonna give you your reset. Once you get your reset, you're free to go. You have a blessed day. Please have a seat in that first chair on the wall. Alvin Wade.
Good morning, all.
Good morning. Okay. Mr. Wade, your full name is Alvin Wade?
Yes, sir.
Mr. Wade, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Wade, you may put your hand down. How are you doing, Mr. Wade?
All right.
You doing all right?
Yes, sir.
Now, Mr. Wade, you're represented in your cases by your attorney, Attorney Jack Lawrence. Mr. Lawrence, how are you doing?
Just fine, Your Honor.
And Mr. Lawrence, do you waive a record in Mr. Wade's cases?
Well, we have a plea agreement, in which two cases are being dismissed. So I would like to submit this as an exhibit, but, we can waive any other record.
Okay,
It's marked as Exhibit 2, Judge.
plea agreement. Okay, that's right. He already has it marked. Okay, now, Mr. Wade,
Yes, sir.
I have before me a document that is titled Information and Cause Number 25 CCCR 1764. In this document that was filed by the Jefferson County District Attorney's Office, it alleges that you, Alvin Wade, on or about July 6th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of deadly conduct. Mr. Wade, do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Or you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Wade, I also have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials, AW, on a line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. You recognize this
Yes,
document?
sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Wade, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge?
You do.
Mr. Wade, are you a citizen of the United States?
Yes, sir.
So offered, Your Honor.
State, state has offered State's Exhibit Number 1. You have any objections?
Can I see it?
State's Exhibit Number 1 is on the tablet that,
Oh, yes.
You signed.
Yes, no objection.
okay, no objections. State's Exhibit Number 1 is admitted. And, Mr. Wade, your attorney is, Mr. Jack Lawrence. Are you satisfied with his services?
Yes, sir.
And Mr. Lawrence, you've advised and counseled Mr. Wade. Is there any evidence that he is currently mentally incompetent to stand trial?
None at all, Your Honor.
Mr. Wade, I will accept your plea of guilty, excuse me. The plea of no contest. I will also find that you are mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement, Your Honor, has been are as follows with the following essential terms, and it has been deduced also into writing, which would be submitted as State's Exhibit number 2, Judge. The essential terms of the plea are as follows. That Mr. Wade agrees to plead no contest to the deadly conduct which occurred here in Jefferson County, Texas, against Miss LaCree Clark, Judge, and that the parties agree that an appropriate punishment would be a sentence of 270 days in a Jefferson County jail. He will receive credit for some of the time which he's already served, which is only 81 days, Judge. In consideration for the plea, the state will dismiss failure to IDs that are charged in criminal number 25 CCCR 2502 and failure to ID as charged in 25 CCCR 3508. There's a sum and substance of the agreement. Is that correct, ma'am? I'm sorry. I need to change it.
Okay, you can make it.
Judge.
Okay.
3058?
Yes.
With those corrections, Your Honor, the state will tender to the court, State's Exhibit 2.
Okay, and Mr. Lawrence, do you have any objections to state?
No
Exhibit two?
objection, Your Honor.
Okay, no objection. State's Exhibit number 2 will be admitted. And Mr. Wade, the state is offering that you serve 270 days in Jefferson County Jail. You'll be given credit for the 81 days that you have already served. What is the court cost in this case? The court cost in this case is $277. Are you able to pay the $277 court cost? Okay, Mr. Wade, I'm going to hand to you a document. I'm gonna hand this to your attorney. He'll hand it to you. This document is titled Affidavit of Indigence. And I need you to just review this first page. Do you recognize that document, Mr. Wade?
Oh, yes, sir.
Is everything in that document still true and correct today?
Yes, sir.
Okay, Mr. Wade, the court is going to find that you're indigent and pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the $277 court costs will be waived, which means you will not have to pay it.
Yes, sir.
Now, Mr. Wade, the state will be dismissing cause numbers 25 CCCR 3058 and cause number 25 CCCR 2502. Mr. Wade, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Wade, I'll follow the plea bargain agreement that you have entered into with the court. Mr. Wade, just have a seat in jury box, and then when the bailiff is ready, she's gonna call you, or she may bring the paper to you so that you can finish signing.
Can I ask one more question? Do I have to give you a good time?
That's up to the sheriff.
Oh,
Yeah. All right.
thank you.
You welcome. And Mr. Lawrence, you're free to go, and you have a blessed day.
Thank you, Your Honor.
I will sign
Okay.
those. The dismissals on the computer now.
Yeah, oh.
Yeah.
You do? Okay, Shane must have did. Okay.
Oh, no, that's on Jay Stone.
Yo, that's somebody else.
Yeah, Jay Stone.
Yeah. Okay. Let's see, Michael Jenkins?
Then it's,
Yeah, she can come up here with
yeah.
it. Okay, this is cause number 25 CCCR 2492. Case is style of state of Texas versus Michael Jenkins. Mr. Jenkins, is that your full name?
Yes, sir.
Mr. Jenkins, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Jenkins, you may put your hand down. How are you doing? That's good. Now, Mr. Jenkins, you have someone here with you. Who do you have here with you? She's not the lawyer, I don't think. Ma'am, what's your name? Alice Jenkins, his mother? Ma'am, thanks for coming down here with your son. Now, Mr. Jenkins, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. It has signature on here that purports to be yours and have some initials up here on a line that state that you would like to hire your own attorney. Now, did you sign this document? Okay, so your mother signed this document on your behalf? So is there any, you cannot sign your signature? Is that because she, if he can sign it, he should sign it? Okay, let me do this here. Okay, in light of my observations and in light of the information that I have before me, the court pursuant to Article 2604 of the Texas Code of Criminal Procedures, subsection C. The court finds that the defendant, based on the court's observation and information, require representation, and the court is going to make an appointment in the interest of justice. Okay? So the court is going to appoint him an attorney based on the interest of justice. And that's pursuant to Article 2604, subsection C. All right. So just have a seat, and then just doing it. No, the court is going to make the appointment in the interest of justice.
Okay.
So we can get him to fill out, not him, but his. Ms. Blackwell, your full name is Maria Blackwell?
Yes.
Ms. Blackwell, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Blackwell, you may put your hand down. How are you doing, Ms. Blackwell? You doing fine? That's good. Ms. Blackwell, I have before me two documents. First document. Okay. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Well, these are your initials on the line that state you like to apply for court-appointed attorney. I also have a document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes.
And on page 2 of this document, there's a signature above the line that's titled Defendant's Signature. Recognize, is this your signature?
Yes.
Now, Ms. Blackwell, before you sign and initial these documents, did you read the documents? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Blackwell, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, our bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. And I'm going to go over this document with you. And it reads, following return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of a defendant named herein or ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
May I add, where we can add her name, Judge, to the actual honor? The
Okay.
complainant in the case, her name is Shakara Barnes, and she's to have no contact with her.
Okay, what's the
SHA
SHA
KARON
KARON
Barnes, BARNES,
BARNES.
nor her minor children, Judge. Ages 9 and 4.
Nor who minor children.
This is Ms.
You said her.
I'm sorry, Ms. Barnes, the complainant's children, since they were witnesses in the case as well. Judge. Ages 9 and 4.
Okay. She has 2 children.
I don't know.
Respectfully, Judge, they were next door.
Okay, I just need, because I can't put the
$20.
children's name.
No, we wouldn't have that, Judge. That's why I just
Yeah.
put that
Unless we
2
put
minor
the
children
initial.
of their ages, Judge.
I'm saying we can put the initials.
I think the age is sufficient, Judge.
Well, by the time this come up, the age is gonna change. Yeah, the age is gonna change. But I mean, like, suppose the bond is forfeited and then a year later. And
They still be
you say
children.
minor
just put- I'll
children
just-
ages,
I will win. Okay, I'll just leave off the ages, Judge.
okay.
I think
Okay.
this matter should be resolved before they reach
Okay.
the age of majority.
Yeah, I'm just trying to be clear, because
Yes, sir.
okay. Now, do you understand that?
Yes.
You can't have any contact. You cannot you cannot communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim, Shakira Barnes, nor Shakira Barnes' minor children.
That's correct.
Lena, you understand that?
Yes.
And condition number 4 doesn't apply. That only applies in the DWI case. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm ammunition unless the defendant is a peace officer as defined by section 101.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay. Now, Ms. Blackwell, if you violate any of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes.
Okay. Have a seat in that first chair on the wall and wait for your name to be called. That's Keithia Holloman. Okay.
Yeah, if I was in your pocket, I put on your paper forms.
Ms. Holloman, your full name is this
You said it right.
Keithia Patrice Holloman?
Basically.
Okay, Ms. Holloman, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Holloman, you may put your hand down. How are you doing, Ms. Holloman? That's good. Now, Ms. Holloman, before we go any further, I think I've met you before. Is that correct?
The Crazy Kitchen.
Okay, the restaurant. Now, you and I have never talked about the fact that you had a case in this court. Is that correct?
No.
And I have never made any promises regarding the outcome of this case.
Correct.
Is that correct?
Yes, sir.
And of course, you've never even asked me about or said anything about the case to me. Is that correct?
We didn't know nothing about it.
Okay. Now, made this disclosure, this public disclosure as we're required to do. And state, do you have any objections to me presiding over this case?
Absolutely not, Judge.
Okay. You waive any conflict of interest or any propriety of, what is it called? Impression of impropriety, any impressions of impropriety or appearances of impropriety.
Of course, we waived that before this honorable court, Judge.
Okay. Now, Ms. Holloman, I have before me a document, actually, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have a document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this document,
Judge, can we pass this case?
pass.
Okay. Yes, sir.
Okay, just have a seat and we'll get back with you. Pass, we're gonna come back to it. Just have a seat. Okay. Latricia Janelle Jones, is that correct?
It's Janae.
Janae, okay. Why is that got a L on it? Ms. Jones, how are you doing?
Okay.
That's good. Ms. Jones, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Jones, you may put your hand down. Ms. Jones, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for a court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Ms. Jones, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Jones, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day. Please have a seat in that first chair and wait for your name to be called. Travis Gage. Mr. Gage, your full name is Travis Gage?
Yes, sir.
Mr. Gage, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gage, you may put your hand down. Mr. Gage, I have two documents before me. The first document is titled Digital Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Gage, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Gage, I read your answers. Based on your answers, you meet the eligibility for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will also be given information to contact him. But before you're given that information, I need to give you some bond conditions. And Mr. Gage, would you please stand? Okay.
Go ahead, Greg.
What did you? Marcus Wilkerson. Yeah, Mr. Gage, I have some bond conditions, and it's titled Standard Bond Conditions in County Court Law Number 2. You see that title?
Yes, sir.
And it reads as follows. Following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number, 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any resident school or other location frequented by the alleged victim. And you need the name of that.
Yes, sir. The name of this case, on it is Thomas Gage.
Thomas.
Yes, Judge. Let me. One second, Judge. Now, this may be a little difficult, Judge, but yes, sir, it's Thomas Gage, and the address is 3200 Bryan Street, and that's in Groves.
3200.
Yes, sir.
How you spell Brian?
B-R-
B-R-Y-A-N-T.
Bryan, B-R-Y-A-N.
Right.
Yes, sir. It's just no other way to say this, Judge. That's his dad. He can't go to his dad and mom house. And
Okay.
you want his mom name too? She's
She's
involved in
not the
case.
victim.
No, sir.
Yeah.
She's the witness in the case, but
Yeah.
that's fine. You know what mom and dad.
Okay. Now, do you understand that?
Yes.
Now, also, the allegation number 4 doesn't apply to indeed the case. However, not allegation, but condition number 4 doesn't apply. Condition number 5 does apply in this case. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand the condition? Okay. Now, if you violate any one of these conditions, Mr. Gage, your bond can be revoked, and if your bond is revoked, a warrant be issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay? All right. Just have a just have a seat in that chair and wait for your name to be called.
I can let you know this, Ms. Holloman, Judge.
Hold on a minute. Okay, let's see. Natasha Rogers. Ms. Rogers, your full name is Natasha Rogers. Ms. Rogers, you please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Rogers, you may put your hand down. How are you doing, Ms. Rogers? That's good. Now, Ms. Rogers, you are, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for court-appointed attorney? Sir, that door is locked. And also had and is this your this is your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indians. Recognize this document?
Yes.
And on page 2 of this document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
Now, Ms. Rogers, before you signed and initialed these documents, did you read the documents?
Yes.
Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Rogers, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is attorney Don Boudreaux. Attorney Boudreaux will give information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information, you'll be free to go. And you have a blessed day. Please have a seat in that chair on the wall. Jennifer Fontenot. Ms. Fontenot, your full name is Jennifer Joy Fontenot. Ms. Fontenot, would you please raise your right hand and you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Fontenot, you may put your hand down. How are you doing, Ms. Fontenot? I'm doing fine. Thanks for asking. Now, Ms. Fontenot, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to apply for court-appointed attorneys? I also have a document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there is a signature above the line that's titled Defendant Signature. Is this your signature? Now, Ms. Fontenot, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Fontenot, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. Please have a seat in that second chair on the wall and wait for your name to be called.
Thank you.
Did I get Ryan? Stay. I'm supposed to give him some bond conditions. Yeah. Robert Glasgow. Is your full name Robert Jack Glasgow?
Yes, sir.
Mr. Glasgow, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Mr. Glasgow, how are you doing?
Decent.
Decent? That's
Yes.
good. Now, Mr. Glasgow, I have before me two documents. First document. Okay, now, Mr. Glasgow,
Yes, sir.
I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. Glasgow, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Glasgow, let me do this here. I'm gonna go off the, so. Now, court is back in session. Court is in session in cause number 24 CCCR 0228. Case is style of state of Texas versus Nikita Patrice Holloman,
It's keeping.
Nikita Patrice Holloman. Ms. Holloman, state, I have before me a motion to dismiss this case. Is that correct?
That is correct, Your Honor. A necessary element of the offense, the facts does not support. Therefore, the state would not be able to sustain this burden and we move to dismiss the case.
Okay, and Ms. Holloman, I'm signing this dismissal. You'll be able to get a copy of the dismissal from our court coordinator. Once you get a copy of the dismissal, you're free to go and you have a blessed day.
Thank you so much.
And I sent you all the others. Don't go away.
What way?
Alvin, was it Alvin one?
Yeah.
I sent two.
Yeah. That was part of the plea agreement, so it's,
Oh, Mr.
The way
Wade,
to-
yeah,
yes.
that's the guy that,
the two fair attorneys.
yeah.
Mr. Law.
Chase.
Okay, do we have, here, it's right here. Did I send it back?
You just sent me the Holloman?
Yeah, that's her right there. And, we're gonna need, we gotta appoint, someone to represent Miss, it's,
And I gave you his affidavit.
oh, that's what that, okay. Yeah, here it is.
You had them to fill out another.
Don't take it.
No, okay. Oh. They didn't have,
So now she can.
yeah, they filled, this was filled out,
That's what he must have been at the jail, so.
but it wasn't signed.
He probably bonded out before we got it, and that's why he wasn't appointed an attorney.
So the affidavit of indigence is in the file.
Getting-
Now, Mr. Jenkins, we're gonna appoint, I think it's Miss, who's next? Christy Carlton is going to be his attorney. Okay? We're gonna have them to come on up. Mr. Jenkins, won't y'all come back up? Now, they had, filled out something at the jail. Let me do this here. And it Your case is gonna be reset. You've been appointed an attorney. Her name is Attorney Christy Kaufman. She will be given permission to contact you, and you and your mother will be given permission to contact her. Okay? So just have a seat, wait for your name to be called, and when your name is called, she's gonna give you your reset. All right? You have a blessed day. All right, now make sure you stay in contact with the folks in Spindletop.
Yes, sir.
Okay. Mr. Glass, told you was previously sworn in, is that correct?
Yes.
Now, I see you made some changes on your affidavit of indigence. Is everything on this document true and correct to the best of your knowledge?
Yes.
Mr. Glasgow, I read your answers. Based on your answers, you meet the eligibility requirements of the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Giles Cole. Mr. Cole will be given permission to contact you, and you will be given permission to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go, and you have a blessed day. Thank you for being patient with us.
Thank you, sir.
All right, have a seat in that chair and wait for your name to be called. Document that is titled Standard Bond Conditions. And you recognize this document?
Yes.
Now, Mr. Glasgow, it states following return of criminal information in County Court Law number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state of the United States. Do you understand that condition? That's number 1.
Yes, sir.
Number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and a test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense.
Miss Heather O'Neill, Judge. Heather O'Neill.
Is it O'Neill's, O-N-E-A-L,
Correct, Judge. O apostrophe N-E-A-L.
or apostrophe? Okay. Now, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim, Heather O'Neill. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Now, Mr. Glasgow, if you violate any one of these conditions, oh yeah, okay. The bond can be revoked, and if the bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay. Just have a seat in that first chair and wait for your name to call. Once your name is called, you go to the window and you'll be free to go and you have a nice day.
Do we have any bond forfeitures? I don't, Judge? I didn't.
Hold on, I think so. Wow, what up?
What's on? The current name is Dallas Code. It should be done the control. Number you can add. If you have any questions before, they.
Okay, thank you.
Thank you.
That's it.
You too.
Okay, this is, cause numbers 25 CCCR 1514, cause number 25 CCCR 1515. Both cases are style of state of Texas versus Fabian Reynolds. Fabian Reynolds is scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's barely called the name of Fabian Reynolds at the courthouse door. Fabian Reynolds did not answer. Fabian Reynolds has not appeared in court since the court has been in session. The time now is 1 p.m. on today's date of January 6th of 2026. Ms. Bailiff, would you please call the name of Fabian Reynolds at the courthouse door? Yeah.
What problem?
Yes,
No response.
Fabian Reynolds' name was just called again at the courthouse door. Fabian Reynolds did not answer. A reasonable time has passed to give Mr. Reynolds an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
The state moves to, bond forfeiture, Your Honor, and warrant issue.
Okay. Fabian Reynolds, well, that motion will be granted in each case. Fabian Reynolds' bonds will be forfeited. The warrant should be issued for his arrest and cause numbers 25 CCCR 1514 and cause number 25 CCCR 1515. And this will conclude the calling of the court's arraignment docket on today's date of January 6th of 2026 in County Court at Law number 2. Oh, somebody's on Zoom. Who is on Zoom?
This is Jason Stovall.
Oh, Mr. Stovall, okay. Okay. Now, Mr. Stovall, you need to, hold on a minute. Mr. Stovall, please put your mic on mute. Thank you. Yeah, Mr. Stovall,
Yes, Your Honor.
we just been informed that you, hired Ryan Gertz on your case.
That's correct. Yes, Your Honor.
Okay, stay in contact your attorney, Ryan Gertz. Okay, he did not, he did not make an appearance here, but you need to contact your attorney, okay? And your bonds, yeah, it's not gonna be forfeited. Is that correct, State?
That's correct, John.
Okay. Yes, contact your attorney, okay?
Okay, is the case being reset, or did I just need to talk to them?
Yeah, we'll get a reset to your attorney.
Understood.
We hadn't got a date yet, okay?
Understood. Thank you.
All right. Bye. And this will conclude the calling, of course, docket, arraignment docket on today's date in County Court Law Number 2, Jefferson County, Texas, Judge Terrence L. Holmes presiding.